Good day, ladies and gentlemen, and welcome back to another What If video. In today's video, I will be discussing whether the signing of CCMA or bargaining council referral forms by an attorney can result in the case being dismissed. Now, as we know, in unfair dismissal disputes relating to conduct or capacity, legal representation is not automatic. A party who wants to be legally represented in these disputes must apply for legal representation in terms of Rule 25 of the CCMA rules or the corresponding bargaining council rule. If such an application is made, the arbitrator will consider the application and grant or refuse the application by taking into account the factors listed in Rule 25. The CCMA and bargaining council rules are binding on all parties appearing, and should a party fail to comply with the rules, that non-compliance will not be without consequences. Now, relevant to our discussion is whether the signing of a referral form, in other words, the LRA 711 or the LRA 713, by an attorney in a matter where legal representation has not been granted, whether that is allowed or not. And if it is not allowed, does that or would that result in the referral being defective and the case being thrown out or dismissed? Now, the case I want to discuss today is the matter between Adams and the National Bargaining Council for the Freight and Logistics Industry and others. Now, in this matter, the representative attorney of Mr. Adams, the applicant, signed the referral forms on behalf of Mr. Adams, who was dismissed for misconduct. So, Mr. Adams was dismissed for absconding, and after his dismissal, he referred a dispute to the Bargaining Council. As I have mentioned earlier, the dispute referral forms were signed by the attorney and not Mr. Adams himself. The matter was conciliated, however, conciliation failed, and the dispute was then subsequently referred for arbitration. Again, the request for arbitration, the 713 form, was signed by the attorney and not the applicant. At the arbitration, the employer's representative raised a jurisdictional point, arguing that the council did not have the necessary jurisdiction to hear the matter, as the referral forms were signed by someone other than the employee and was therefore fatally defective in terms of the council's rules. Now, the commissioner agreed with the views of the employer's representative and accordingly found that the matter cannot be heard. In other words, the commissioner found that the bargaining council does not have jurisdiction because of the fatally defective referral forms. The employee, Mr. Adams, was not happy with this outcome, and he challenged the commissioner's decision on review to the Labour Court. The Labour Court found in favour of the employee, and the employer, being unhappy with the Labour Court's outcome, took the matter on appeal. Now, the Labour Appeal Court considered the rules of the Bargaining Council, and the court found that, similar to the CCMA rules, the Bargaining Council rules preclude the automatic right to legal representation of parties in dismissal for misconduct or incapacity disputes, unless obviously legal representation is applied for and granted by the arbitrating commissioner. Rule 6 of the rules provides that a document, and this is an interesting rule, a document that a party must sign in terms of the Act or in terms of these rules must be signed by a party or by a person entitled in terms of the Act or the rules to represent that party in the proceedings in question. And this simply means that the employee should have personally signed the referral forms because the attorney did not have the right to represent him as of yet, because there was no application for legal representation that was granted. So on the merits, the Labour Appeal Court found that both the conciliation and arbitration forms were fatally defective as they were signed by the employee's attorney, who did not have the required standing to sign the documents on behalf of the employee. The Labour Appeal Court found that this resulted in fatally defective non-compliance with the rules. The court accordingly found that the ruling wherein the commissioner dismissed the employee's case was a correct decision. Therefore, and in conclusion, a referral form signed by an attorney who cannot represent an employee or the employee is a fatal flaw, and it will result in the matter being dismissed. Employees would be able to re-refer their disputes. However, the second referral or the re-referral may be outside the prescribed 30 or 90 days, and the employee would be required to apply for condonation. Now, as you are aware, there are several things that we look for, that you need to look for when you receive a CCMA referral form from a jurisdictional point of view. One thing that we may have overlooked in the past is who signed the referral form. Now, this case clearly sets out that attorneys who has not been granted the right to represent cannot sign the forms on behalf of clients. And if that attorney signs that form on behalf of a client and legal representation has not been granted, we know now that the CCMA does not have jurisdiction to adjudicate the matter as the referral is defective. Now that brings us to the end of this video. I will see you in 2 weeks' time. Bye-bye.